ended our synchronous session with um, the kinds, okay, of deed. So we learned 4 kinds of deed: corporate surety, property bond, cash deposit, and recognizance. We discussed each of the 4. Now, let's proceed to Rule 114, Section 2. Okay? Para saan ang deed? We know for the fact that um, it's a security deposit. But all kinds of deed under Rule 114, Section 2 are subject to the following conditions. Okay? So ito yung mga undertakings. Okay? Una, the undertaking shall be effective upon approval, and unless cancelled, shall remain in force at all stages of the case until promulgation of the judgment of the RTC. So for example, the case is in the MTC, and then you have been convicted in the MTC and you want to appeal the case, you can still use your bail actually, because again, the bail here shall remain in force at all stages of the case until promulgation of the judgment of the RTC. Yes, there is promulgation, but it is in the MTC level pa. That is why you can still make use of your bail pagdating ng RTC pa. Okay? Because yan yung sabi ng condition. Irrespective of whether the case was originally filed in or appealed to it. Okay? Second, the case or the accused shall appear before the proper court whenever required by the court of this rule. So meaning to say, yan yung isa sa mga undertaking na require ng rules. When you take up bail, hindi pwedeng mag-absent ka whenever the court requires you to be there. So you have to be there. If you are the lawyer of the accused, you make sure that your client is there during the hearing. Because again, kung hindi siya magpakita, most probably the judge will forfeit the bail. Why? Because you disobey or you violated your undertaking under Rule 114, Section 2. Okay? Next, the failure of the accused to appear at the trial without justification despite due notice shall be deemed a waiver of his right to be present thereat. In such case, so does it mean to say na kung wala ang accused, hindi magpapatuloy yung trial? The answer is no. It will continue to run. Okay? And the trial is considered as a trial in absentia. Bakit? Absent man si accused. So, supposed to be, dapat nandun ka eh. Kay, that is part of your right to know all of the weaknesses of the prosecution and to cross-examine the weaknesses of the prosecution. But that does not mean na kapag wala ang accused, the trial will not proceed. The trial may still proceed, especially if the failure of your appearance is without justification, despite due notice. Okay? And number 4, the bondsman, either you yourself or another person, shall surrender the accused to the court for execution of the final judgment. Okay? So kapag tapos na po yung case, na-convict ka, the bondsman shall surrender. The bondsman could be the accused himself or could be another person. When you say another person, sa kanya, siya ang may-ari ng money or ng property, or siya yung corporate surety, siya yung representative, authorized representative ng corporation. So if that is the case, ang sabi ng rules, dapat kapag mag-promulgate na ng judgment, you make sure that your accused na piyansahan nimo, dapat nandun siya. Okay? Because that is part of the undertaking. Shall surrender the accused to the court for the execution of the final judgment. Okay? So, yeah. The original papers shall state the full name and address of the accused, the amount of the undertaking, and the conditions herein required. Now, photographs passport size taken within the last 6 months showing the face, left, and right profiles of the accused must be attached to the bill. So, yan yung if you happen to observe the records in court, kapag nakapiyansa yan sa yung mukha ng yung mukha ng accused, nandyan talaga yan kasi required yan ng 114 section. Photographs in passport size. So front, right, and left. Is this a mugshot? No, hindi yan siya mugshot ha. It's actually a photograph or it's photographs taken for purposes of the compliance under Rule 114 section. Okay? Any question from the class? Yeah. Okay. Now, if you are on bail or if you are an accused, hindi ka manadakip, can the private complainant or the prosecution apply for the whole departure order? Meaning to say, deprive you of going outside the Philippine territory. The answer is yes. Okay? And it is allowed. Okay? However, under the rules, only the RTC can issue a whole departure order. Municipal trial court or the first level court cannot. Okay? And this is not a violation of the accused's right to travel. That is allowed para malimit natin or ma-secure natin yung presence ng accused during the pendency of the case. The application for bail may be filed and acted upon by the trial court despite the filing of a notice of appeal, provided it has not transmitted the original record to the applicant. Ano ba ibig sabihin niyan? For example, nakapagpiyansa ka during the time na nakonvict ka na, especially this happens, MPC nakonvict ka and you want to appeal in the RTC. So you elevate the case. Before elevating the case, you can still apply for bail. And remember that in the MPC level, the bail is a matter of right, whether before conviction or after conviction. So the application for bail may be filed and acted upon by the trial court or by the MPC despite the filing of a notice of appeal. Basta, tingnan natin na, or masiguro lang natin na yung record sa MPC sa case na yan, hindi pa na-transmit going to the appellate court, which is the RTC. However, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed, paid, and resolved by the appellate court. Okay? So, possible kasi na mag-change ang kanyang judgment or ruling pagdating sa appellate court. And it is possible that in the original court, it is non-bailable, pero pagdating sa appeal, na reverse or na change yung ruling ng court, and it becomes bailable this time. So, because it's bailable, you can now apply for bail. Okay? And it can only be filed saan? Before the appellate court. Should the court grant the application of your bail, the accused may be allowed to continue on provisional liberty. Remember, this is not a permanent liberty, only provisional. While the case is pending, you are free to roam around or go or to travel. Okay? During the pendency of the appeal under the same bail subject to the consent of the bondsman. Okay, so remember that the bondsman's consent is needed, especially if the bondsman here is a person different from the accused. Okay? So this rule requires that kailangan pumayag yung bondsman na gamitin pa rin yung bail para sa appeal. At the hearing of the application for bail filed by a person who is in custody for the commission of an offense punishable by death, reclusion perpetua or life imprisonment, the prosecution has the burden of showing that the evidence of guilt is strong. Remember that even if bail is a matter of discretion, that does not mean to say that hindi na siya makapagpiyansa. It is still possible that that person who is accused of a crime punishable by reclusion perpetua, life imprisonment, or death penalty, even if ganun yung punishment sa kanya, okay, possible pa rin na makalaya siya. Okay, possible pa rin na makapagpiyansa siya. Kaya lang, because this time it's punishable by life imprisonment, death, or reclusion perpetua, this is not a matter of right. This is a matter of discretion. So there is no guarantee na makapagpiyansa ka because we will still, or the court will still hear your petition for bail. Okay? And the prosecution, ang sabi ng rules, the prosecution in that proceeding has the burden of showing that the evidence of guilt is strong. Ibig bang sabihin kapag the evidence of guilt is strong, na-determine ng court na evidence of guilt is strong, talagang convicted na ang accused. Hindi pa, because it's still bail hearing. Bail hearing pa lang po yung pinag-uusapan natin. We are not yet hearing the main case. Okay? So, i-determine lang ng court kung yung evidence pa ng prosecution is strong. Okay? Kung weak, then most probably the court will grant your petition. But if the evidence of guilt is strong, then the court will deny your petition for bail. Now, this is what you call bail hearing. This is not the hearing of the main case. Hearing of the bail lang po. Ang issue lang po sa bail hearing is whether or not the evidence of guilt is strong. Now, once nakapag-present na po yung prosecution ng evidence sa bail hearing, ang sabi ng rules, the evidence presented during the bail hearing shall be considered automatically reproduced at the trial of the main case. But upon motion of either party, the court may recall any witness for additional examination unless that witness is already dead or outside the Philippines or otherwise unable to testify. Wala na tayong magawa dyan. That's Rule 114, Section 8. Now, let's jump to Rule 114, Section 18. In the application for bail under Rule 114, Section 8, the court must give reasonable notice of the hearing to the prosecutor or require him to submit his recommendation. Okay? So, ano ba yung guidelines? Sino ba yung magsiset ng amount ng piyansa? It's the court. Okay? The court is the one that will set the bail amount. Ano yung guidelines ng judge in setting the bail amount? Okay? Magkano yung piyansa? Magdedepende yan siya under Rule 114, Section 9. Okay? Always remember that the court is guided by the constitutional provision na excessive bail shall not be required. Remember Article 3, Section 14. But in the rules, paano ba natin nadidetermine kung magkano yung siniset ng judge? Ano yung mga factors na kinoconsider niya? The judge who issued the warrant or granted the application shall fix a reasonable amount of bail. Well, that's I will just verify pagkada. Right. So, ko lang talagang ma-verify kayo baka isod na mabalikan ko ninyo. Okay. As I was saying, the court in setting the amount of bail is guided by hindi pala Section 14, it's Section 13. Is guided by Rule 11, Article 3, Section 13. Yung last sentence dyan sa Constitution natin, sa Constitution, excessive bail shall not be required. And that is why, even if the judge or even if the court will set the amount, Hindi pwedeng arbitrary yung pag-set ng amount. In fact, Rule 114, Section 9, in your rules provide that the judge who issued the warrant or granted the application shall fix a reasonable amount of bail considering primarily but not limited to the following factors. Una, kinoconsider ng court ang financial ability ng accused to give bail. Pangalawa, the nature and circumstances of the offense na denial sa kanya. At yung penalty for the offense charge. Yung character at saka yung reputation ng accused, kinoconsider rin. Yung age at saka health ng accused, kinoconsider rin. Okay, kinoconsider ang age at saka health ng accused as to the amount, not as to the granting of the bail, but only as to the amount of bail. Ano pa? The weight of evidence against the accused. The probability of the accused appearing at the trial, the forfeiture of other bail, meron siyang history of forfeiture, the fact that the accused was a fugitive from justice when arrested, and pendency of other cases where the accused is on bail. So, ito yung mga kinoconsider ng court in setting the amount of bail. It's not the these are not considerations in whether or not to grant the bail, but these are the considerations used by the court in setting the amount kung magkano. As long as hindi dapat excessive ang bail, because that is prohibited under Article 3, Section 13, and Rule 114, Section 9. Excessive bail shall not be required. So ano lang yung amount dapat? It must be a reasonable amount. Okay? Question from the class? Now, no bail shall be required when the law or these rules so provide. Okay? Example is if the punishment is purely fine. If it is purely fine, then no bail is required. Okay? Another is when the crime is covered by summary rules. Because Rule 114, Section 16 provides that when a case is filed under the summary rules, a mere notice is sufficient. There is no need of a warrant of arrest. And Rule 112, Section 9, Paragraph B is also observed. Okay, we will discuss summary rules in the finance. Okay? Now, when a person has been in custody for a period equal to more than, so what if hindi ka nakapagpiyansa? Okay? Hindi ibig sabihin na hindi ka nakapagpiyansa at tumatakbo yung case. Hindi na dapat i-track yung case mo. You as lawyers must always keep monitoring your clients. Okay? Whether nasa kulungan or nasa labas ng kulungan, you have to keep track. Kahit tapos na po yung kaso, minsan kailangan pa rin natin i-monitor kung tapos na yung client natin. Okay, huwag niyong pabayaan yung kliyente. So when a person has been in custody for a period equal to or more than the possible maximum imprisonment prescribed for the offense charged, what should a lawyer do? Okay? Alam mo na ito yung sentensya or ito yung prescribed penalty ng offense, like 4 years and 2 months and 1 day. For example lang 4 years, 2 months and 1 day lang maximum na dyan niya na penalty. But what happened was that naabot ng 5 years ang imuhang client dito sa kulungan. So what should you do? Nag-exceed na sa maximum imprisonment prescribed for the offense charge, hindi pa rin tapos yung case. So ang sabi ng court or ang sabi ng rules of court, kapag ganyan ang nangyari, he shall be released immediately without prejudice to the continuation of the trial or the proceedings on appeal. Nangyayari yan sa class. Nangyayari yan siya na mas nag-lapse na ang maximum period sa prescribed penalty, wala pa na kuman ang trial. Yan na siya sa pulungan. So even if wala siyang piyansa, at even if hindi pa natin ma-determine kung convicted ba siya or hindi, the fact na na-detain na siya for more than the maximum prescribed penalty, then he should be released immediately. Now, what if there is this minimum of the principal penalty? You appreciate this when you learn your ISL or the indeterminate sentence. No? Diba? Meron tayong minimum, meron tayong maximum. So if the minimum of the principal penalty prescribed for the offense charge has already been reached, ano yung pwedeng gawin ng abogado ng accused? He shall be released, okay, on a reduced fee or on his own recognizance at the discretion of the court without application of the ISL or any modifying circumstances. Okay? Without applying the ISL or any modifying circumstances. Minimum of the principal penalty na serve niya na. So kapag ganyan, hindi pa umabot ng maximum, then ito yung option. He shall be released on a reduced bail or on his own recognizance at the discretion of the court without application of the ISL and any modifying circumstance. Pero kapag umabot na siya ng maximum prescribed penalty, then he shall be released immediately without prejudice to the continuation of the trial or the proceedings. Magpapatuloy pa rin yung trial, magpapatuloy pa rin yung proceedings kahit nakalaya na siya. Okay? So, yan. If the maximum penalty to which the accused may be sentenced is destierro, then he shall be released after 30 days of preventive imprisonment. Please take note of that. Now, here is this question. Saan ba dapat mag-file ng piyansa? General rule, you file it. The answer is found in Rule 114, Section 17. General rule, you file it before the court where the case is pending. Exception is kapag absent or unavailable yung judge ng court na yan. So you may apply for bail with any RTC judge or MPC judge in the province, city, or municipality. But this time, we have this what we call pairing judge. Okay, the pairing judge is important if this circumstance happens. Okay, kapag ito po yung nangyari, na absent yung judge saan pending yung case mo, pero meron man siyang pending or meron man siyang pairing judge. So yung pairing judge niya yung pwede mong lapitan at pwede mong applyan ng piyansa. Now, the exception to the exceptions here is where the grant of bail is a matter of discretion or the accused seeks to be released on recognizance. Because in this case, the application may only be filed in the court where really the case is pending, whether on preliminary investigation, trial, or on appeal. Okay, wala tayong magawa dyan. Any person in custody who is not yet charged in court, saan mo yan siya, saan ka magpa-file ng piyansa? Question, pwede na bang makapagpiyansa ang isang tao na hindi pa tapos yung inquest? The answer is yes. Ang tanong na lang dyan is saan mo ipapile yung piyansa mo? Where do you think you will find your bail? You may apply for bail with any court in the province, city, or municipality where he is held. But I highly recommend that you file it before the executive judge. Okay? In the FEC, meron yan siyang executive judge dyan. That is the proper court where you will file it. Sa RTC naman, executive judge, RTC. Okay? Now, if the accused is arrested in the province, city, or municipality other than where the case is pending, bail may also be filed with any RTC of the said place, or if no judge thereof is available with any MPC judge therein, within the same nature. Okay? The accused must be discharged upon approval of the bail by the judge with whom it was filed, and whenever bail is filed with a court other than where the case is pending, the judge who accepted the bail shall forward it together with the order of release and other supporting papers to the court where the case is pending, which may, for good reason, require a different one to be filed. Okay? But again, the exception here is if it is a matter of discretion or if you seek or requisite. Okay, because in that case, doon lang talaga yan pwedeng i-apply sa case or sa court kung saan ang case pending. Pero pag wala pang pending na case, saan mo siya pwedeng i-file? Ang sabi ng rule, you may apply for bail with any court in the province, city, or municipality where you are held. Okay? But itong any court na ito, as I was saying, you better go to the executive judge, the court of the executive judge. Okay? Either in the MPC, executive judge, or RPC of the executive judge. That's my proposal or my suggestion. What are the instances when MPC is entitled to entertain applications for bail? Ano yung mga instances na ang MPC pwedeng mag-entertain an application for bail? Una is where the case is pending there. Okay? So, pwede. But if in cases not feasible by it, filed before it for purposes of DI or investigation would also be. Or special jurisdictions MPC. Okay? Kapag wala yung RTC judges lahat. So, walang choice kundi sa MPC na lang. Now, if you apply for bail with any court in the province, city, municipality, ano yung caption ng petition for bail mo? It is in the petition for bail. Ganun. Kasi wala pang man case title. A municipal trial court judge has no authority to grant bail to an accused arrested outside of his territorial jurisdiction. Please take note of this. King versus Judge Tumlao, AM number MPJ-04-1556, March 31, 2005. MPC judge has no authority to grant bail to an accused arrested outside of his territorial jurisdiction. Okay? In the case of St. Bulan versus Judge Bartolome, AM number MPJ-05-1588, June 5, 2009, banned by Justice Peralta, whenever the bail is filed with a court other than where the case is pending, the judge accepting the bail shall forward the bail, the order of release, and other supporting papers to the court where the case is really pending, which may, for good reasons, require a different one. Now, in the case of Savelia versus Ines, AM number MPJ. Again this gives you the idea, itong case ng Simbulan at saka yung sa Rule 114 Section 17 na pwedeng sa other court ka mag-file ng bail even if that court is not the pending, is not the handling court of the case. Okay? As long as once na nangyari yan, yung nag-grant ng bail, dapat i-forward niya sa court kung saan pending ang case. Okay? Ang order of release, ang records, okay? The bail itself, and other supporting papers. In the case of Savelia versus Ines, AM number MPJ-071673, April 19, 2007, banned by Justice Tina. Here, this is a falsification case against Ines, okay, or against the accused. And it was filed before the MPCC of Bigan. There was no showing of the unavailability of Judge Ante at that time because it's Judge Ante that was the presiding judge of MPCC Bigan. So, because of that case na hindi na-prove na hindi talaga available si Judge Ante, the judge here, who granted the bail, clearly erred in entertaining the bail application despite the knowledge of the pendency of the falsification case before the MPCC of Bigan. And assuming argument that the respondent judge rightfully granted the bail to the accused, her failure to transmit the order of release, the bail, and other supporting papers to the court where the case is pending, another violation of the rules, particularly Section 19 of Rule 114, is committed. Respondent judge should have forwarded the records pertaining to the bail bond immediately after she received the same. Okay, so please take note of that for future judges here. Alam niyo na po ano yung gagawin. We have this case, in re anonymous letter, the complaint against Honorable Marilu Gunes Tama, AM number MPG-04-1558, April 7, 2010. Here, Judge Tama contends that under Rule 114, Section 17, Paragraph A, the accused who were detained and who voluntarily surrendered in San Juan could file their application for bail in San Juan. That the accused detained in Pateros would do the same, and that the bail applications of those detained in Taguig City were legally approved before she was then the bailing judge of MTC Taguig, Branch 24. The Supreme Court said here that Judge Tamang was correct in approving the application for bail of the accused who had voluntarily surrendered and been detained in San Juan, Pateros, and Taguig City, because Section 7, Paragraph A of Rule 114 granted her that authority to approve the applications for bail of accused detained within her territorial jurisdiction in the event of the unavailability of any RTC in the area. It is worth noting that at that time of the subject bail application, there was still no RTC judge stationed in San Juan and Pateros. So, however, the Supreme Court said here that Judge Tamang did not substantiate her explanation that she had approved the bail applications of the accused detained in Pasig City and had issued the corresponding release orders after office hours on Friday because no RTC judges had been available in Pasig City. Aside from the affidavits attesting that she had stayed and worked in her office until 9 o'clock in the evening, and that the orders of release had been immediately served on the jail warden concerned, she offered no proof to justify her approval of the questioned funds. Dito siya nahulog. Therefore, her explanation did not exculpate her for truly her approvals of the bail bonds constituted an irregularity arising from her lack of authority. Okay? Now, let's go to Rule 114, Section 20. Rule 114, Section 20. After the accused is admitted to bail, okay, the court may, upon good cause, please take note of that, upon good cause, either increase the bail amount or reduce the bail amount. Pero kapag ang ginawa niya is increase the bail amount, the accused may be committed to custody if he does not give bail in an increased amount within a reasonable period of time. So pwede pala na even if na-set na yung bail amount, pwede pa rin yan siya upon good cause. The court may still increase it further or to reduce it. Okay? An accused held to answer a criminal charge who is released without bail upon filing of the complaint or information at any subsequent stage of the proceedings, and whenever a strong showing of guilt appears to the court, may be required to give bail in the amount fixed per the leader of completed custody. That is Rule 114, Section 20. An accused held to answer a criminal charge who is released without fianza upon filing of the complaint or information at any subsequent stage of the proceedings, and whenever there is a strong evidence of guilt, okay, and when he appears to the court, he may be required to give bail in the amount fixed. Kapag hindi siya makapagbigay ng bail, then he may be committed to custody. In the case of Conquilia versus Bernardo, AM number MPJ-09-1737, February 9, 2011, the Supreme Court said here that while Rule 114 allows a judge to grant bail in bailable offenses, and to increase or decrease the bail, it assumes that the judge has jurisdiction over the case. That is the presupposition here. Now, can your bail be forfeited? The answer is yes. It can be forfeited. Remember na hindi yan sa pambayad, okay, yung bail, sa security deposit. Later on, pag matapos ang kaso or kapag isa sa huli yung accused, then pwedeng masahuli din sa iyo yung bail bond. Okay? Ngayon, ang sabi ng Rule 114 Section 21, when the presence of the accused is required by the court for these rules, his bondsman shall be notified to produce him before the court on a given date and time. Kaya nga dapat hindi mag-absent yung accused during trial or during the proceedings kapag nagpag-bail ka, because most probably ito yung nangyari. If the accused fails to appear in person as required, then his bail shall be declared forfeited. Magagalit ang court. Kasi nga, di ba, nag-promise ka na isa sa mga undertakings mo sa bail is dapat hindi ka mag-absent. And nag-absent ka. So, the court may declare your bail to be forfeited. Kapag na-forfeit yan, hindi mo na yan masasahuli sa iyo. And the bondsmen given 30 days within which to produce their principal and to show cause why no judgment should be rendered against them for the amount of their bail. Within the said period, the bondsman must, letter A, produce the body of their principal or give the reason for his non-production and explain why the accused did not appear before the court when the first required to do so. Failing in these two requisites, a judgment shall be rendered against the bondsman jointly and severally for the amount of bail. Goodbye bail. Okay, diba? Then the court shall not refuse or otherwise mitigate the liability of the bondsman unless the accused has been surrendered or is acquitted. Because yan talaga yung pinaka-importante dyan. You are supposed to be in prison. You are supposed to be detained. It's just that you applied for bail. And that liberty that you are enjoying is just provisional. That provisional liberty attaches therein are some conditions that you have to be there in court whenever the court needs you. So the court may forfeit your bail if you will not appear at the time and date that is required of you to appear. Okay? In the case of Talag versus Judge Reyes, AM number RTJ-04-1852, June 3, 2004, penned by Justice Inares and Chag, the Supreme Court here, this case says that complainant blames the respondent for his failure to appear at his arraignment because the notice was sent to the wrong address despite a prior notice for change of address. The reading of the notice of change of address will show that it pertains to the counsel's residence and not to the complainant's. The Supreme Court said here that it becomes reasonable for the court to assume that court process will be sent to the complainant's old, okay, and unchanged residence. Okay? So as correctly pointed out by the judge, the produced order of the December 11, 2002 and January 22, 2003 settings were sent to the complainant's bondsman. Hence, in accordance with Rule 114 Section 21, his bondsman must produce him before the court on the given date, and failing to do so, the bond was forfeited as it was. It's correct. In the case of Mendoza versus Alarma, GR number 151970, May 7, 2008, penned by Justice Carpio. Here, two occasions upon which a trial court judge may rule adversely against the bondsman in cases when the accused fails to appear in court. Una, kapag non-appearance. Second, when the bondsman, after the summary forfeiture of the bond, are given 30 days within which to produce the principal and to show cause why a judgment should not be rendered against them for the amount of the bond, and hindi niya ginawa. Okay, so yan. It is only after this 30-day period during which the bondsmen are afforded the opportunity to be heard by the trial court that the trial court may render a judgment on the bond against the bondsmen. Judgment against the bondsmen cannot be entered unless such judgment is preceded by the order of forfeiture and an opportunity given to the bondsmen to produce the accused or to adduce satisfactory reasons for their inability to do so. Ano ba ibig sabihin yan? Balikan ninyo ang Rule 114 Section 21. Kapag hindi nag-appear ang accused during the scheduled date and time, then the bond will be forfeited. Now, the thing here is that sometimes the bond is not owned by the accused himself. Like for example, naghangyo lang ang pamilya sa accused na mangutang or buramon ang titulo sa laing tao para gamiton for bond. Now, if that happens, okay, if that happens, bibigyan ng chance ng court, ang bondsman na i-produce yung accused. Okay? Yes, forfeited na po yung bond, but it doesn't mean na hindi yan siya mababalik doon sa may-ari talaga, sa third person. Ngayon lang, ang sabi ng rule is that you are given 30 days within which to produce the accused. If you fail to do that, okay, then you are jointly and severally liable for the amount of the bill. Meaning to say, yung bond mo talaga yung madedehan dito. Okay? So, yan yung ibig sabihin dyan. Confiscation of the bond. So, yan. Let's go to Rule 114, Section 22. Okay. Before that, let's go back to the case of Mendoza versus Alarma. It is only after this 30-day period during which the bondsmen are afforded the opportunity to be heard by the trial court that the trial court may render a judgment on the bond against the bondsman and not against the accused, because in the first place, the forfeit na yun sa accused. Judgment against the bondsman cannot be entered unless such judgment is preceded by the order of forfeiture and an opportunity given to the bondsman to produce the accused or to adduce satisfactory reasons for their inability to do so. Here, the accused failed to appear in person before the court and that the trial court declared his bail forfeited. Because the bond is provided by a different person, okay, so third party po yung bondsman dito. The bondsman, respondents in this case, a 30-day period was given. Okay? However, 2 years had passed from the time the court ordered the forfeiture and still no judgment had been rendered against the bondsman for the amount of the bail. Instead, an order of execution was issued and the property was put up for sale and awarded to petitioners the highest bidder. Kasi property pa namin. Supreme Court said that there was a failure of due process of law. The execution was issued not on the judgment because there was not, but simply and solely on the declaration of the forfeiture. An order of forfeiture of the bail bond is conditional and interlocutory, there being something more to be done, such as the production of the accused within 30 days. This process is also called as the confiscation of bond. Such order is different from a judgment on the bond, which is issued if the accused was not produced within 30-day period. Kaya nga iba. The judgment on the bond is the one that ultimately determines the liability of the surety. And when it becomes final, the execution will issue at once. The law was not strictly observed in this case, and this was violated. Respondents right to procedural process. Okay? Rule 114, Section 20. Let's go here. Rule 114, Section 22. Upon the application of the bondsman with due notice to the prosecutor, the bail may be cancelled upon surrender of the accused for proof of his death. The bail shall be deemed automatically cancelled upon the acquittal of the accused or the dismissal of the case or execution of the judgment of conviction. In all instances, the cancellation shall be without prejudice to any liability of the party. Please take note of that. In the case of People versus Kawali, GR number 157147, April 17, 2009, penned by Justice Nachura. With the conviction of Kawali for murder and the court's consequent failure to execute the judgment of conviction because of Kawali's flight, the motion must be denied. The posted property bond cannot be cancelled, and much less withdrawn and replaced with a cash bond by one cruise unless kawaling is surrendered to the court or adequate proof of his debt is presented. So hindi mo yan siya pwedeng ganun eh, especially in payment pagkita. Hindi na natin makakilap yung accused. For the purpose of surrendering the accused, the bondsman may arrest him even without a warrant of arrest, or cause him to be arrested by a police officer or any other person of suitable age and discretion, competent authority endorsed on a certified copy of the undertaking. An accused released on bail may be rearrested without the necessity of a warrant. Please take note of that. If he attempts to depart from the Philippines without permission of the court where the case is pending. Okay? So if he attempts to depart from the Philippines without permission of the court where the case is pending. In the case of Silverio versus Court of Appeals, okay? So again ito, I really tried this in actual case, ito Rule 114 Section 23, where my client wants to go abroad, okay? And because the case is pending, we ask for a court's permission na makatravel sa abroad while the case is still pending. And nag-promise na kami na during the time na mag-hearing, babalikin siya. Okay? The court denied my motion in the sense that sabi ng court, wala man kami nag-issue ng whole departure order. And so, because there is no whole departure order directing or prohibiting the accused to leave the country where the case is pending, then the accused can freely go as long as pag-set ng case, dapat nandito siya. But Rule 114 Section 23, if you try to read again Rule 114 Section 3, it seems that if you are released on bail, you may be rearrested without the necessity of warrant if you attempt to depart from the Philippines without permission of the court. And that's the reason why I filed for a motion to permit the accused. Pero the court still denied it because wala daw whole departure order. By all means, you can leave. Okay? So you just have to take note of this. Hindi na ako nakipag-argue sa court, but Rule 114 Section 23 is very clear. Kapag pending ang case, walang hijud sa korte na mag-travel ka abroad. Okay? Otherwise, you may be rearrested if you do that. In the case of Silverio versus Court of Appeals, April 8, 1991, Article 3, Section 6 of the 1987 Constitution should by no means be construed as delimiting the inherent power of the courts to use all means necessary to carry their orders in effect in criminal cases pending before them. Marcos versus Sandigan Bayan, GR number 115132 and 34, August 9, 1995. Please read that case. And Manotok versus Court of Appeals. A court has the power to prohibit a person admitted to bail from leaving the Philippines. This is a necessary consequence of the nature and function of a bail ban. Because remember that you are just enjoying a provisional liberty. The condition imposed upon the petitioner to make himself available at all times whenever the court requires his presence operates as a valid restriction of his right to travel. Now, even if the court wants to grant your permission to leave, but kung sabi ng bondsman, no, the court has no power to grant your request because the bondsman must also agree, except that if the bondsman is yourself. May a court trying a criminal case issue a full departure order motu proprio to prevent the accused from leaving the country, even if the prosecution did not file any? The answer is yes. The case of Santiago versus Gachidorena, December 2, 1993 says that the full departure order is but an exercise of the court's inherent power to preserve and to maintain the effectiveness of its jurisdiction over the case and the person of the accused. Okay? So with that, you read circular number 39-97. This is the guidelines for issuance of full departure order. Remember that MPC does not have the power to issue the whole departure order. Okay, question from the class? Any questions from the class? Wala? Okay, so let's stop here. And on the next video, we will proceed to Rule 115 and Rule 116. We are almost done for the midterm coverage. God bless everyone and have a